Attend the court, please.
Please be seated. Oh, sorry, go ahead.
The Honorable Supreme Court of New Mexico.
Please be seated. Welcome to snowy Santa Fe this morning. Glad everyone made it. Okay. All right, we'll try that again. Good morning. This is S-1-SC-40105, Amdor versus Grisham. I have entries of appearance, please.
On behalf of the petitioner, Jessica Hernandez and Paul Kennedy, and also present in the courtroom are Brian Lane and Gregory Baca.
Thank you.
Good morning, on behalf of the respondents, Holly Ice, Katie, and Kyla.
Thank you. All right, Ms. Hernandez, it appears that you have elected 15 minutes for your argument in chief and 5 minutes for your reply. Is that correct? All right, you can take it away.
Ms. Hernandez, before you start,
Like you launch.
what order is before us? What is before the court today? Because as I understand it, you had the September 8th public health order when the petition was filed, and there was an amended, then there was a second amended, and then since then, there's been 2 more extensions with no new public health orders. So please educate me on what we're here to hear today.
Good morning.
Yes, good morning.
I can do that. I can start there.
Now you know I haven't been sleeping all week and wondering about this question.
The public health orders that were originally, I'm sorry, the first executive orders, as you know, were in September. They have been extended or renewed essentially every 30 days. Most recently, the executive orders at issue were renewed on December 29th, and they go through January 26th.
Where can we find that? Because I think many of our chambers have looked and looked and looked and looked and looked and looked, and we can't even find a copy of the current health order.
The public health order or executive order?
Either way, the one leads to the other, so probably focusing on the executive order. Extraordinary amount of time has been spent looking for it.
The executive orders are available on the governor's website.
Not as far as we can tell.
That's typically
Not your problem.
That is typically where
But I have hit refresh
them?
like 60 times, including this morning,
So
and it's not. So
I think if you frame it in the sense of it was not renewed, I think that's where the court is coming from. If it has not been renewed, then we can't see that it has. How does that change what our obligation is and what your argument?
But if you have a copy, so you are assured that it has been renewed, that would be important for us to know as well.
I do have the copies. They They are my copies, and so they are marked. I'd be happy to
No,
provide
I mean,
them
I
to the
I will
court.
take on its face value your representation and Ms. Agajanian nodding, saying, yes, we agree that it has been renewed. So probably quickly, well, I'll adjust time because this shouldn't take up all of your time. What does the newest order tell us? Because none of us have seen it.
The renewed executive orders, and there have been, I believe, 4 renewals of each, because they have been each 30 days. The order related to a public health emergency due to drug abuse is Executive Order 2023-147. And the executive order related to gun violence is Executive Order 2023-146. And their content is identical, essentially, or in substance, it is the same originally. What changes is that it simply references the earlier renewals by date, and it says that that the governor has found that the continuing nature of the public health emergency requires the renewal of the order. And each time it is extended for 30 days.
Okay.
So the most recent orders say this order shall take effect immediately and shall remain in effect until January 26th.
But that's the executive order. Did the public health order get renewed?
The public health order, as far as I can tell, has been renewed twice since the original. It was originally September 8th and then renewed on September 15th and renewed again on October 6th. It's my understanding that the October 6th public health order is the one that is in effect.
So that's for our purposes of our conversation today, I think you would recognize that that's what controls the conversation as opposed to necessarily the one that was filed originally in terms of the substance of the argument.
I think that it's relevant that it's been renewed because we are still under its effect. It is operative right now.
Okay.
This is still something that is capable of repetition at any moment, but that mootness argument is not an issue because it is currently in effect. And the public health order says that it shall take effect on October 6th and remain in effect for the duration of the public health emergencies declared in Executive Orders 2023-130 and 2023-132, and any subsequent renewals of those public health emergency declarations. So on their face and by their terms, they are still in effect.
So now I'm going to jump in because now we've hijacked everything you wanted to do, but we're known for doing that. Where my mind has focused over the last several days is trying to understand the difference between, under these facts in particular, the difference between non-delegation and public question. And there's not really much out there on the distinction. They seem to be at least close cousins. And so I'd like to understand your arguments as it relates to non-delegation and political question, and how do we parse the two out?
Chief Justice, both of those threshold questions point to the same answer, which is that this is absolutely an issue that the court should consider. And the non-delegation issue really talks about the fact that because this is such a quintessentially legislative area, public safety, that, and when we get to the language of the statute, it's very clear just from the plain language of the statute that this was never what the legislature intended as far as the delegation of emergency powers to the executive. But the non-delegation doctrine would say that the legislature, even if it tries, is simply not allowed constitutionally to delegate that type of authority.
So even if it said in the statute, including gun control, including drug abuse, the legislature can't tell the executive, we want you to do this?
Justice Vargas, I believe that is true. Yes, that the non-delegation duty and the separation of powers constitutional provisions would prevent that. That's not before the court because the Constitution and the statutes are very clear that it is the legislature that has the police power and even the emergency power. And that is only a limited delegation.
So you're talking, let's put the gun portion of the order aside, do you agree that some of the issues in the public health order are probably things that didn't require the declaration of an emergency and were within the authority of the executive branch anyways, such as the treatment facilities or things of that nature? I mean, I think those are things that aren't necessarily policy, but things that are well within the right of the executive branch anyways. So if you'll tell me, unless you think the whole order is outside the authority of the executive branch, if that's the case, if you'll explain that.
Justice Zamora, I can do that. And the answer has two parts. First, the executive orders are so far outside and so contrary to the emergency statutes that in their entirety, they are invalid. By trying to declare a state of emergency based on, quote, gun violence and, quote, drug abuse. And if we look at the plain language of the statute, the Public Health Emergency Response Act is meant to deal with public health issues. Throughout its provisions, it is talking about quarantine, isolation, public health facilities, public health supplies. It's talking
I wanna
about
push
disease.
back on that a little bit because we have the term in, I mean, the legislature actually defined public health emergency, which is at least nice for us that there's some definition, and it says a dangerous condition or a toxic agent. So drugs are, fentanyl is a toxic agent. I find it hard to figure out how that isn't there. And a dangerous condition relates, I think there's a decent argument that it relates to gun violence. So I understand that it's, you want, your clients want to focus on the highly infectious disease part of it, akin to COVID. But the statute itself says dangerous condition or a highly infectious or toxic agent. So it's in the disjunctive. So how do you square that with dangerous condition or toxic agent, that viewpoint or the argument that you're presenting?
It's still, Chief Justice Bacon, it is still an emergency statute that is meant to be used when there is some imminent threat. And that's the reason that public safety issues, absent some very extreme and acute occurrences, simply are in a different category from the type of sudden, unforeseen. There was nothing sudden or unforeseen.
But where in the
about these
statute does it say
conditions.
it has to be sudden or unforeseen? It just says it has to be imminent. Those aren't necessarily the same thing.
The definite, Justice Vargas, the statute talks about the occurrence or imminent threat of exposure. So occurrence,
Something that happened.
that is something that happened, but it also
One time.
It implies one time, not a constant state. And that's part of why the governor's argument is so strained and unworkable. In her response, she points to case law that deals with dangerous conditions under the Tort Claims Act, dangerous conditions in schools or on public property. That kind of state of being argument would never work under this statute. That was not the intention. This statute, and it's very, the emergency statutes are intended to provide power for 30 days or unless renewed.
So is the concern, we're moving around a lot. I mean, is the concern the renewal? You know, what we're getting at is we need, if we were to agree with you, there has to be a standard. And I'm not clear what your standard would be for the executive. Can the executive not execute an order outside of public health? Can the executive not renew it after 30 days? Where do you butt up against the delegation problem? Tell us what your standard is for this executive in issuing a public health order.
There are two parts to that answer, Justice Thompson. One is that it needs to be something out of the ordinary. It can't be our constant state of being. It cannot be the public safety issues that we face each and every day and that the legislature legislates on every single session. Public safety is one of the most heavily debated topics in the legislature. And it's the most classically It's the most classic legislative power, the police power, health and public safety. The governor,
Have been COVID, so there is some health, of course, that would be covered. So you're saying, I guess this is where I'm having a hard time with your argument is if you look at the Model State Emergency Health Powers Act and what many states have adopted, that's much more narrow than what New Mexico has adopted. So if we just talk about health situations that are completely unexpected and out of the ordinary, and we limit it to that, then why wouldn't the legislature have adopted something similar to the Model State Emergency Health Powers Act? In my mind, because the legislature went beyond that, they didn't just intend for it to be something like COVID or something completely unexpected and unforeseen.
Justice Zamora, we don't know exactly why the legislature chose to adopt certain portions and not others of that model act. But the Constitution itself puts emergency powers with the legislature. In Article 4, Section 2, emergency powers, it specifies that the legislature shall have all powers necessary to the legislature of free state, including the power to enact reasonable and appropriate laws to guarantee the continuity and effective operation of state and local government by providing emergency procedure for use only during periods of disaster emergency. These statutes, which by their terms are intended to have very short timeframes, are intended to make sure that it is only in a situation where there is an acute crisis that the legislature would not have time to act on. This came up in the COVID cases, in Grisham versus Reeb, Grisham versus Romero. This court had to decide, and the COVID lasted. That was a longer emergency, but at least it was novel. It was unprecedented. That word has been thrown around a lot. And the court took judicial notice of how severe the risk was. And but even in that situation, and this was most clearly articulated in Justice Thompson's concurrence in the Romero case, where he talked about the idea that the longer a crisis goes on, it reaches a point where it is in a more managed or regulated state, which is exactly what the state of New Mexico is dealing with gun violence and drug abuse. The statistics in the response go back to 2010. This is an issue that we know is plaguing our communities. And the debate is important, but it is entirely contrary to our system of government for one individual to have the power to subjectively decide that quote emergency has reached some unspecified level so that they can invoke emergency powers and start to substantively impose public policy decisions through that executive order.
So Ms. Hernandez, I need to understand who to your mind or your client's mind is the bad actor here. Who has exceeded their authority or not done their job? Because here the legislature handed this authority to the governor and said, here you go. We want you to have this broad power. And it seems to me that your argument today is really focusing on what the governor has done, as opposed to what the legislature has done. And so, in my shorthand, and it sounds more pejorative or draconian than it does, but I was like, who's the bad guy here? Is it the executive? Is it the legislature? Because the legislature under Cobb has the ability, no question, to do something that is broad sweeping. The court has previously upheld that. It doesn't completely prevent the legislature from vesting a large measure of discretionary authority in administrative officers and bodies, which here would be the executive. The essential inquiry is whether the specified guidance sufficiently marks the field within which the administrator is to act, so that it may be known whether the administrator is kept within the compliance of the legislative will. So the legislature here as a body, when they were debating the model code, said model code, and did something different. Very few states did something different. And so if you peel that back, the legislature was very intentional in saying, we want the executive to have this large measure of authority. And I think part of that is our legislature meets either 30 days or 60 days. And so you've got the rest of the year where you have to be able to jump in and do something. So to your client's argument, is it the legislature that has messed this up? Or is it the executive that has exceeded that authority? And I promised you I'd give you more time, so of course you can answer the question.
Chief Justice Bacon, the legislature has been clear in delegating authority for use in emergencies. If you dig into the language of both the Public Health Emergency Response Act and the All Hazard Management Act, all of those provisions have terms that are clear on their face that they are intended to deal with situations that are much more time-bound. COVID was the exception that pushed that a little bit to the limit, but that was much different of a situation
Doesn't
than this.
emergency include the definition of something that cannot be a policy decision has to make absent the time for deliberation? I mean, that comes right out of Black's Law Dictionary. And doesn't that, in a certain way, fit what the governor is doing here as opposed to what the legislature has given to the governor? So I'm struggling with like kind of whose problem is this? And if it's a legislative over delegation, is this violative of non-delegation, or does this become a political question? Because if it's a political question, separation of powers dictates a very specific result from this court.
Chief Justice Bacon, these statutes, and it's interesting too that if you look back at the executive, or if the court chooses to take judicial notice of the governor's past executive orders, and I looked at them, in the last 4 years, over 300 dealing with fires, floods, weather conditions, road issues. That is the nature of the emergency power. Here, they're in Unite New Mexico versus Oliver, the Secretary of State was arguing the legislature intended to delegate to me the form of the ballot, which means that I should be able to decide whether there is straight party voting on the ticket. The court looked exhaustively through the history of the statutes that dealt with that issue and said the legislature has had its handprints all over this for decades. That's the same issue with public safety. Gun regulation, drug regulation, extensive legislation over the years. So it is not that the legislature gave too much power. The governor felt like she had to do something. And so she chose to use a tool that, at least in COVID, she was able to use very extensively. But here, when you are getting into areas that are the police power that has traditionally and constitutionally been reserved to the legislature, that is not an overdelegation issue. That is an arrogation of power and a separation of powers issue where the governor has chosen to invoke a statute that is meant to be used in very limited circumstances, but tried to apply it to a very broad problem.
So sorry, buttons. I still can't clear this up in my mind. So you're saying the governor acted outside her authority in just generally declaring drug abuse and also gun violence as public health emergencies. Assuming we agree with you, does that invalidate the authority she has to do any of the things contained in the public health order? Because again, I think some of those things were already within the executive's authority. So what effect does it have if we say, okay, you couldn't declare these public health emergencies? Do we then go to the public health order and say, but these were already within your power and maybe this was not? I mean, how do we, practically speaking, handle this?
Justice Zamora, that's a good question. And to be really clear about what our requested relief is, the emergency orders are invalid because they go beyond the emergency statutes. So those are an invalid use of executive power because it is not part of what was delegated. From there, the public health emergency orders that are issued by the Secretary of Health, they are invalid because they are based on the authority of the executive order and they can only be triggered through an emergency declaration. The public health order is the one that has the substantive provisions.
So
You are correct.
practically speaking, I just want to, practically speaking, then if we were to agree with you and we invalidate and the current PHO fails, 10 minutes later, I think, as the argument would go, the governor could still say, I want wastewater tested, I want to examine, juvenile detention, I want to, the things that are kind of left at this point. She could turn around and just do that through a regular executive order. Is that fair? Subject to, later attack on it, but that, I think that would be her next move, is to say, well, okay, that's fine. And now I'm going to keep doing these things by way of executive order.
Chief Justice Bacon and Justice Zamora, both of you are getting at the same issue, and you are correct that there are provisions in here that if they were done separately, simply under the executive's authority to manage the executive departments, she could do. For example, to tell the Department of Public Safety, I want you to coordinate with Bernalillo County Sheriff and APD to arrest people with warrants. Absolutely.
And that
Absolutely.
would go to your point, I think, that this is not an emergency.
Exactly, exactly. So there are some provisions in there that she could, if these were invalidated, put into place immediately, and they, if challenged, may survive because they are completely within her authority. But to invoke them through the emergency power, that is the overreach. And although there are some provisions that you have identified or mentioned.
It's not that it's an overreach, it's that it doesn't fit within the definition of a public health emergency, and therefore it cannot be used, therefore you can't use the public.
That's not the right vehicle.
It's correct.
That's exactly
And
right, Justice.
it proves the point that it's not an emergency, if you could do it anyway.
That's exactly right. There are certain provisions, though, within the public health emergency order that cannot survive a separation of powers analysis
Which
because,
ones are those?
well, the clearest examples are in part already invalidated by the federal court that pertains to to gun regulation.
Mhm.
Those were struck down within days because they were so clearly unconstitutional. But there are still provisions in there that do regulate when you can carry a firearm, and those are already heavily regulated by the legislature. Fentanyl is already addressed in the Controlled Substance Act, and so if the governor is putting in new provisions that relate to fentanyl, that could be in conflict with those.
But what specific new provisions are you referring to as they relate to fentanyl? Because you're right, it's already a controlled substance. It's already, the legislature's spoken on this. Her job is to execute the laws. What specifically are you talking about that would be outside her authority?
Well, in our briefing, we do address the concerns that are raised by the wastewater testing.
Which is done in other areas. It's not just drugs. I mean, that was probably done during COVID. Are you saying that's not, assuming that it's not a public health emergency, are you saying that's not something the governor has the authority to do under the executive branch anyways?
It is an example. It's an example of one of the provisions that starts to get into areas that the legislature has already addressed or opted not to address. Another clearer example, though, is the suspension of the alternatives to juvenile detention. To suspend a program that the legislature specifically created, and that's in section 9-2A-14.1, where the legislature created the Juvenile Continuum Grant Fund and specified how it would be used, what money would go in there, what the public purpose behind it was. That's public policy. The legislature chose to make that part of the public policy of the state, to have those alternatives to detention. And for an executive to decide, I don't think that's a good idea anymore. I mean, that's something that, at the very least, implicates that statute that the legislature has already chosen to act on, if not directly contradicts it. And so that's part of this problem. One is that it doesn't fit within the emergency statutes, but also that it is touching on areas that are substantive public policy rather than just managing.
Let me ask you, with the chief's permission, let me ask you a question on that. Again, it's going back to the standard, and I want, if I can, focus on, because I think your sharpest sword is the delegation, and I think to the manner in which I can speak to the concurrence as a concern. To talk about Chief Justice's question, that actor here seems to be the legislature. This thing is extremely broad and it's circular and it's self-answering. She declares an emergency and then acts on it. My question is this: when I look at the non-delegation doctrine, I look at federal cases that have been addressed this, because there's not a whole lot of cases that give us a test other than this intelligible principle, which is as vague as the Public Health Act, quite frankly. What precedent do you have where the US Supreme Court has restricted in a delegation case going back to Marshall Fields? I found two, and it involved basically these New Deal cases that say you can't control the economy through all these executive orders. Can you help me identify a limiting principle in federal jurisprudence that has told the executive you cannot, or I'm sorry, told Congress you cannot delegate that authority to the executive?
Justice Thompson, you've touched on some of them already, and I think beyond our briefs, I don't know of other cases beyond what is cited in our briefs, but we did talk about the Youngstown case where it really talked a lot about when the president's power is at its highest or lowest ebb, and it depends on what Congress had done in that area. And here, when the legislature has permeated the area of public safety with its laws, I think that it fits into that type of analysis.
Thank you. Thank you, Chief.
All right, unless my colleagues have additional questions, I'd like to hear from the governor now. Thank you. And I'm going to be the jump right out of out of the gate person.
Today.
Yes, please.
One of my kind of primary questions is what limits the governor's authority under FARA? Is there any limiting principle for us to apply here that pulls this out of the over delegation question?
Sure. I think how I would answer that, and if I'm not understanding you, please let me know. How I would answer that is essentially, I would submit that this court should apply basically a rational basis test to what the governor has done in terms of when she's taking the authority that has been given to her by our part-time legislature. Is there a rational basis for the decision that she's made? And that would, and I would completely agree, that would go for each and every decision. That would go for each and every renewal of an executive order. Is there a rational basis for this one, this one, this one? Okay, so
But isn't that kind of the second part of this overarching test? The first being, does it fit into what a public health emergency is? And the second part being, are the actions that the governor took reasonable to address that public health emergency? How do we address the first part of, does it fit into the public health emergency definition?
absolutely.
And are there any limitations on that?
Okay,
Yeah.
yes, understood. So, the answer that I would give to that, of course, is yes, it is. But here's the thing that, again, that we haven't talked about, that we didn't get to talk about during the first part of this, which is there are public health experts, Secretary Allen, somebody whose job and life has been spent analyzing such things, who has also said this is an emergency. So the policy expert has agreed in this case that this is an emergency. So Secretary Allen has come out
But
and
where do
said,
we draw that line?
sure.
That's where, so that's my
my
overarching.
That is my question.
It's a great question, and I don't know where, it's not a bright line test. And I think that's the hard part. That's the hard part for you all, right? Because it's not a bright line test.
And if there is no bright line, is this non-delegation or is this a political
I
question?
think it's a political question. And if there's not a bright line, but here's what I can say. I know we're on this side of it. I know we're on the correct side of it so far. I don't disagree that this court could put guardrails or could talk about where a line might end. Actually, in one of the COVID cases, the 10th Circuit, go ahead, Justice.
But it's not us putting anything on anything. It's what is the language of the statute. And so the language of the statute says the occurrence or imminent threat or exposure to an extremely dangerous condition. And something that poses an imminent threat of substantial harm. Those are the guidelines.
Those are
And
the
so,
guidelines.
I mean, it's gotta be an imminent threat or exposure to an extremely dangerous condition. Now,
So I really still want an answer
Yeah.
to my question though, which is, what are the boundaries?
those are the boundaries in the statute.
What's your
Those are
answer?
the boundaries in the statute.
Yes.
I think that's too glib a response. And let me explain why. I came up with a hypothetical in my own head about this, of course, which is DUI. No question, a really significant problem in the state of New Mexico. Could the governor suspend the ability of New Mexicans to drive in San Juan County or McKinley County because of that emergency? And so it goes a little bit to what the senior justice is talking about, but I can conceive of almost anything being a public health emergency if I adopt your client's perspective, and maybe that's what the legislature did. But there seems to me there has to be some tether here, and that's what I would like to hear from you about.
Yeah, and I'm trying to, and I think I understand what you're asking, Chief Justice. And what I would say is the steps being taken, the limitations that get put in place have to be balanced against what kind of an emergency we're talking about. Okay, so nobody can drive because we have a DUI problem. That's a heavy blunt instrument. Okay,
But it's very similar to guns.
it's very similar to guns, and I would agree with you too that it's similar to guns in the portion of the initial order that was subsequently rolled back. But now that's not what we're looking at. That is not the universe we're looking at now. And I would actually say right now, any intrusions on the individual liberties of our citizens are de minimis based on this particular public health order and the executive orders. There are, and I would note even in the petition, nobody said, that they have been injured in any actual way as a result of this.
But you still have to manage a public health emergency before you get to that question.
That's correct.
And so to me, to get to the chief's hypothetical, and I had another hypothetical. I saw a statistic this weekend that New Mexico has the 5th highest rate of hit and runs. So based on that, could you make hit and run a public emergency? But it seems to me that DWI, hit and run, perhaps guns even, are not imminent threats. And that's what the statute makes a distinction. And if that is true, there's nothing that I see in the declarations or in the public health orders demonstrating that gun violence is an imminent threat.
How do we know when the water is boiling? I think
it's a
that's-
completely fair question.
That's not a fair question to me.
But how do you know when it's imminent as opposed to this chronic versus imminent? How do you know when the water is boiling as opposed to hot?
Yes, and that is, and the way I've also thought about it sort of similarly is like, when is one drip too many, right? And because again, we have, there's a quote I was looking at earlier today from 2021 of the head of the Republican Party, Steve Pierce. We have a crime crisis in our state, a public emergency, and the Republican House leaders are absolutely right. And we can use emergency to mean different things in different contexts, I'm assuming, right? So when is just one drop too many? But there's one portion of this that I think we haven't discussed that I think is important. The nimbleness and the flexibility that this statute gives the governor is also the ability to fund programs to examine the problem. Okay, so, and a great example is the gun buybacks. So those gun buybacks, we just had one over the weekend. I believe it was 1,100 or 1,300 guns.
Was it necessary to declare a public health emergency to do that? Or were some of these, I feel like a lot of these things were already within the authority of the executive branch.
And I think you're absolutely right for the MCOs, for example, and directing them, that is completely within the authority of the executive to do that. The gun buyback was funded with some of the money from the executive order. So it's a release of funds to help deal with this. The wastewater testing was funded through the executive orders. So it gives the governor the flexibility and the nimbleness to be able to look at what she sees as a problem, an emergency in her position, and she is the executive elected to make those decisions in consultation with her public health experts, and fund it to look at these problems and to study the problems and to figure out what the best treatment is. And waiting, a year for the legislature to come into session to maybe or maybe not fund programs that can help us study this is simply too little, too late.
Does the fact that this public health order, and if you can correct us on the record, has been renewed 4 times, does that inform our view, reading the statute, of whether this is imminent? To me, it's signaling, and a lot of states like Ohio, Pennsylvania have a time limit. And to me, that signals you were transferring the power from the executive to the legislature at that point. Am I incorrect in that? After 4 renewals, are we going from exigency to permanent policy?
I would say after 4 renewals, no. And again, as the concerns that you expressed in Romero, I think are right on the money. I don't think we're there yet. And I don't know when we would get there, but I don't think that we are there. And let me just,
But the session is about to start, and you can always call a special session, or the legislature can call an extraordinary session. So I hate to rely on the fact that we have a part-time legislature and they only meet once a year. To me, that's not a justification to take the power of the purse away from the legislature or some of these policy decisions.
and Justice Zamora, the legislature has already given the governor that, the access to the purse in this one specific regard, in this one specific statute. One thing before I get too far off track, Justice Thompson, that I want to make sure we're all talking about the same things. The executive orders need to be renewed every 30 days by statute. The public health orders do not expire. They are not renewed public health orders, they're amended public health orders. So each public health order is a little different. I actually had clean copies of the most recent executive orders and the most recent public health orders, and then I started scribbling on them during this argument. We're happy to supplement by the end of the day today. And I apologize that you couldn't find them. I'm confident that our paralegal has dug a hole with her toenail and is hiding in it for when we get back. Those are supposed to be online. So
Yeah,
I
it ends in
sincerely apologize.
2003.
Yeah, I apologize.
Right.
But we will supplement that by the end.
Which
But-
I appreciate.
But what does give it the force of law is the executive order.
That's absolutely correct.
Right.
I just wanted to
That's
make sure
what-
that we were
sure.
talking about the same universe of documents.
Thank you.
So guardrails and limitations. Talk to me, please, about the relationship between 1210A5B, which sets forth what the declaration must contain, must specify, and how that fits into a public health order that then follows. Because it seems to me that there are guardrails, so to speak, in subsection B. You have to say the nature of the public health emergency, the political subdivisions or geographical area affected. You have to set forth the conditions that caused that emergency, the expected duration, the people that are needed to assist. And then it says any other provisions necessary to implement the executive order. So it seems to me that those are all limitations to you have a generic definition of public health emergency, but then this specifies what has to be in there. And I'm not so sure I'm not convinced anyway at this point that the declarations in this case satisfy all of these requirements. It's just generic. We have percentage of this, percentage of that, so forth. And so please explain that to me. I know that's a long question.
No, that's okay, Justice Beal, and I would respectfully disagree that it's generic, because if we look at the drug abuse public health order, one of the things that we talk about within there, or I'm sorry, within the, now I'm getting all my orders confused and
Welcome.
they specifically carve out, and I know, and I heard you when you said statistics and percentages, but to my mind, that is the information that we need. The 100% increase in a certain population affected by gun violence in the last 2 years
So
is specific.
where is the statistical information showing that gun violence in public parks in Albuquerque and in Bernalillo County is a problem? There's nothing in these declarations that show that.
So, Your Honor, first of all, what I would say, number one, is that the petitioners have also talked about how that's already sort of cooking in federal court there. But what I would note is that there actually is authority for the fact of the mental health component for children about having to do active shooter drills, for having to live in a country with the spectrum.
That's not in the declarations.
I believe it's in the public health order in a footnote, Your Honor.
It's in
but I
the
could be
order, but
mistaken.
not in the declaration.
I
there's
understand what you're
nothing
saying.
in
It's in the public health order, but not in the executive order.
Correct. And there's nothing in the executive order either that talks, this thing in the public health order about suspending and immediately suspend the juvenile detention alternatives initiative. That just jumps out. There's nothing in the executive order supporting that.
Well, so the juvenile, that particular initiative is a funded program, and it is a pot of money given to CYFD to spend at their discretion. It's not an obligation to spend on their part. And the other part about it, Justice Vigil, is if you read the last part of that sentence, and that has to do with evaluating probation procedures, which is really what has been happening at CYFD. And I could tell you very specifically what that means. In the past, there has been, I'm going to call it the Arnold tool, but it's not, but essentially a metric that is used by juvenile probation officers when a juvenile has been involved in a violent crime or a crime involving a gun. Okay, and that test, that metric can have different points. It's a point system as well. And depending on the score, the juvenile probation officer, the JPO, may or may not, even at the scene, direct the officer to release the juvenile, regardless of whether a gun has been used, because of the score on the test. That's the evaluation that is happening at CYFD. Is this a good tool? If you have a child or a juvenile that has used a gun to commit violence, the idea of releasing him or her at the scene needs to be thought about and needs to be studied. And that is, I think, appropriately within the purview of CYFD, which does go to Justice Zamora's point, which is that we don't necessarily need an order to do that. But that particular component is something that I do think needs to be studied and concerned. And there's not a directive that they must spend the money. They get the discretion to figure out.
I'm not questioning that. That was the point I'm asking is whether or not the declaration of a public health emergency, that declaration has to justify that action. And I don't see anything in the declaration that supports that. If there has to be a connection between the two,
Yeah,
as I understand.
and I don't disagree with you, Justice Vigil. I guess I would respectfully disagree with you on the merits of that point, is that I do think that there's an adequate amount in there. And I do think that the orders, the executive orders and the public health orders adequately carve out the scope of the problem and the solutions to the problem. And again, what I would go back to is the idea that when we're looking at this and whether there's been somebody exceeding any authority, you have to look at the tools or the measures that are being taken. And in this case, there is nothing that is any more than a de minimis, frankly, inconvenience, if even that, for folks under the terms of these orders. Wastewater testing, you don't know if that's happened to you or not, right?
Yeah.
But I also think, again, one of the interesting things about this, and something that has been so instructive for the governor and for the public health department or the Department of Health, is when you do this wastewater testing, which again was funded pursuant to the governor's authority under these orders, so we had the money to do it. Looking at those, at the test results to find out the wheres, but also to find out the whats. When you see the different controlled substances that are turning up in the wastewater, it's a little bit eye-opening and it's quite a bit surprising in a lot of ways. Because I think everybody makes assumption about what's going on in schools and what our juveniles are doing and perhaps what our faculty is doing. But those programs, again, the very, very de minimis impact on society at large, are continuing to carry with them tremendous benefits for our public health department.
So let me
Right, is it
ask you,
fentanyl or is it coke?
Both.
I mean, just to use, or is it everything?
It's
Is
both.
it-
It's,
is it
it's
everything? And
fentanyl,
that's
it's
horrible.
cocaine, but but
It's
not
not
heroin. I mean, it's a very
Yeah,
interesting.
heroin's passe now.
Seventies and eighties. I know.
Exactly.
But no, it's a very interesting,
I don't,
Study.
I don't think you're gonna lose the case on
On the
on the
wastewater testing.
Yes.
wastewater. So I appreciate that. Quite frankly, I don't think governor needs public health order statute to do those things. The more concerning question is where we really start to begin to intrude into either policymaking or some other constitutional boundary. What part of the current order that's in effect, public health order, executive order, with regard to the right to bear arms is still being litigated in federal court?
parks and playgrounds in Bernalillo County. That is it.
so I guess my, and I've made my position clear. I think a lot of this could have been done without a public health order. But now that you're telling me that the only way these things can be funded is with a public health order, it seems to me that we're giving, I mean, if we construe it that broadly, that a governor under numerous circumstances could declare something to be an emergency and decide how funding will be allocated or what programs will be funded, that go well beyond this order. I mean, how do we put any, I still don't get the guardrails we put on. If we allow this, what are we not allowing?
I think that's a completely fair question. And again, I don't know where the line is, Justice Moore. I really don't.
So then it doesn't become non-delegation? Or are we going to say to the legislature, go figure it out? I mean, because those from a separation of powers perspective are two very different outcomes. Because one, it's us declaring what the boundaries are. And one is saying legislature, go figure it out. I mean, those are very, and I'm not entirely comfortable that we are the body to set that policy, but my colleagues, I think, clearly have different thoughts about that. So which path do I go down? Because they feel like both.
I understand. And I think that the points that were made earlier are important and well taken. Our legislature very specifically enacted a broader statute with broader discretions. And if the legislature has the votes to change that, then they can change it. And that's where the guardrails are in terms of the funding and in terms of the broadness of the statute. That's the bill, that's the rule. Those are the powers that the governor has, and those are the powers that she was reelected to continue to use, again, in consultation with her public health experts about what constitutes an emergency. If the legislature has a problem with the funding mechanism, with the renewal mechanism, with any other part of it, they are free to amend that statute.
To the point, as I understand your test then, to the point in which we get involved, if the executive issues an order, we look at each directive and we apply tier scrutiny to each. So if it involves a Second Amendment, we would have heightened scrutiny. If it involves wastewater, there'd be lesser scrutiny. Is that what the test is? If you were to say, sounds like it's a broad statute, I don't disagree with that. It's a very broad statute. So, okay, now we have executive order. Now it comes to us. And we have to figure out what is beyond the scope of the executive's authority and what is within it. Is that what you're telling us the test is? Look at each one and apply some tiered scrutiny to it.
I think, Justice Thompson, that the answer to that question is you have a couple different questions in front of you. Does the executive have authority to declare the emergency? Is this an emergency? And is what the executive done constitutional? I mean, those are really three separate questions. And I think that if you're examining each and every portion of it, you might have to look about whether there's one aspect of it.
And then
Let me
we
ask you
also-
about,
Go ahead.
sorry, let me ask you about the, is this an emergency part of it? Because that's really been bothering me. During COVID, everybody agreed, we took judicial notice that COVID was an emergency. I'm concerned about how we determine what is an emergency here. Do we have to have you guys have provided us, the governor has provided us with lots of statistics, lots of statements about the problems that we're facing with gun violence and with drugs. We've heard a little bit from the respondent in response. We don't have any evidence. We don't have any findings. That's not what we do. How do we determine what is an emergency without any evidence, without any hearing, without any findings?
Justice Vargas, that may be why a mandamus proceeding is inappropriate at this juncture. But, sorry. Excuse me. But what I would also remark to that is that that is where we rely on the public health experts. And that's why we have our cabinet secretary, who is a public health expert, who's a subject matter expert, who has weighed in on the subject. And it is his job, and he is appointed by the governor, who's been elected by the people, to make those decisions.
You know, in Ohio, they decided banning gender affirming surgeries is also a public health emergency. So the rules we write apply to everybody,
Yes.
this executive and others.
And that kind of goes to the point I was making a couple minutes ago, which is about, you know, you have to look at the different tiers of what's happening. Is there the authority? Is the authority being appropriately used? And is the methodology or the orders within it, are those constitutional as well? Okay, thank you.
I think each of you has asked the governor's council the same question in different forms. Where is the line? And multiple times she said that is a completely fair question, and she never answered where is the line, and that is the problem. Here, whatever this court decides, it is, if this court decides that this executive is allowed to take 13 years of data and subjectively decide these public health, these public safety issues have reached what I deem to be a state of emergency, completely unilaterally and completely subjectively. One drop has become one drop too much. That opens the door to every future executive to make those same kinds of decisions on the same kind of data on any number of public
But is
safety
that the
issues.
governor's problem or is that the legislature's problem? I'm going right back to where I left off with you. The legislature said here, and the governor has embraced the here. So whose fault is this? Because I think we, at least for your clients, we think of it in terms of, who's outside the boundaries. To me, it feels more like a legislative problem because they're the ones who wrote this and were very, very deliberative about it. As opposed to the governor saying, okay, well, they gave me this power, I'm going to use it. And it's the way I get to release funds. And because yes, the governor can order somebody to go test wastewater, but if there's no money to do that, then it's an exercise in futility. So whose fault is this? Or is this a political problem that we shouldn't be touching?
Chief Justice Bacon, the legislature has been clear, and the questions from Justice V. Hill on imminence get to the heart of that. The statute is very clear. This has to do with imminent threats. Imminent threats. There is nothing imminent about a public safety issue. There is 13 years of data in front of you to support this invocation of emergency powers. That is not imminent. That is chronic. That is chronic. That's a constant issue that
But what
faces.
happens if you're tooling along, and I'll use gun violence and I'll make up some numbers. Gun violence example, we're having X amount of gun violence in a community, and then we wake up one morning and it skyrockets. Isn't it that skyrocketing that makes it imminent as opposed to chronic at that point?
There are two aspects of the test that this court has wrestled with and decided it can wrestle with and make those decisions. Is it imminent, and is a legislative solution workable? That's part of what the court looks at when it's dealing with emergency cases. And Justice Zamora is exactly right. In 8 days, the legislature convenes. The governor has said publicly that public safety will be very prominent on her proclamation. One of the petitioners in this case, Representative Ream, has already pre-filed 5 bills related to these issues. A legislative solution is workable because it is on the table for next week, starting next week. But Any other issues, the same
But
hypothetical.
assume with me it's April. I mean, that's a very convenient timeline right now, but so assume with me we're sitting here in April.
The backdrop would be the same, that the legislature has addressed this over and over and over. And the hypothetical about a spike in statistics, that could apply to any of those other issues. It could apply to poverty or homelessness or domestic
I
violence.
agree with you, but that's what the legislature decided to do. So I'm not sure why you're so wedded to this is the governor's fault. I mean, it might be because some of your clients are legislators. Granted, they're legislators in the minority, which I fully appreciate the challenges that go along with that. But I'm struggling with why this is beat up the executive when I can see a path that's not the executive. What did the legislature do?
If the court reads those two statutes in their entirety, it is very clear that they are not intended to deal with issues like this. Even though the phrase public, dangerous condition exists.
Toxic agent?
Right. The statutes in their entirety make very clear this is intended for public health issues or disasters or acts of war or riots, very acute issues. So I think the deeper you get into the statutes, the clearer it becomes. This is not a legislative problem in being too vague. The delegation has some dangers in that it gives the executive the ability to be prosecutor, judge, and jury
Yeah,
in deciding that, but that's where this court steps in.
And I don't necessarily disagree with that. It's just whether there's a constitutional infirmity with it. Let's go to imminent danger. So this branch is good at a lot of things. Imminent may not be it, right? We're deliberate. Acts applied to the law. We have briefing, make decisions. Imminent belongs with the executive. They're the one that execute laws and deal with things in emergencies. To go to Justice Vargas' question, what is the process? If you are asking us to decide this is not imminent, whatever they said is imminent is not imminent, are the five of us looking at this paper record and studies and deciding this is imminent or it's not? Is it a fact finding? Is there an administrative process for this? How does that work? Or can we just decide, the five of us, not elected every 4 years, every 2 years, every 6 years, what is imminent?
Justice Thompson, I think that because of the separation of powers issues that are involved, this court should weigh into this issue. It is not a factual question. I think that even though there's a lot of data in the response, the fact that it goes back 13 years to describe that spike is pretty telling in itself. So I think that the nature of the issue and the fact that there's not an argument that spike happened last week. That's just not before the court. 13 years of data, 2010 through 2022, I guess 12 years of data is what the respondents put before the court. So that you're just not in that situation where you would really have to be weighing detailed factual information by category. The idea of gun violence or drug abuse, those are such pervasive problems, and the data goes back so far before you that you are capable of, as a court, as a matter of law, looking at that information coupled with those statutes in their entirety and what they were intended to address and how far these go into quintessentially police power, public safety issues, and the separation of powers danger that is created if one person is allowed to subjectively decide that this last drop is simply too many. That is not what our system is designed to do. These issues are simply too important to cut the legislature as the representative elected branch out of that process.
Can't the legislature do something about it as opposed to us? I mean, that's the fundamental question.
Well,
So that's really, it's a rhetorical question because your time is well past.
I do have a question.
Okay, briefly, please.
If the court decides that the governor has failed for whatever reason to properly declare a public health emergency, or that this is not a public health emergency, is it necessary to get into the non-delegation question?
Justice Hill, I don't believe it is, no.
Thank you. All right, thank you, counsel. We appreciate your arguments and we will get you a decision as time permits. Thank you.
10 to 4, please.